What is agency? By the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another, with the consent or authority of the latter. What is the extension of personality? In an agent principal relationship, the personality of the principal is extended through the facility of the agent. In so doing, the agent by legal fiction becomes the principal, authorized to perform acts which the latter would have him to. Example: A appointed M, a minor, as his agent for the sale of his car. M, pursuant to the said authority, was able to sell the same to B. Soon thereafter, due to the COVID pandemic, the price of the car soared high, which then prompted A to assail the validity of the sale, claiming that the sale is void since his agent is a minor. Can A avoid the sale on the ground of M's incapacity? No. In a contract of agency, insofar as third persons are concerned, what is important and material is the capacity of the principal to enter into a contract. This is because the agent's personality is a mere extension of the personality of identity of the principal. In this case, it is undeniable that the principal A has all the capacity to be bound in a contract of sale. What is the doctrine of representation? The basis of agency is representation. The law, in fact, contemplates impersonal dealings where the principal need not personally know or meet the third person with whom the agent transacts. The purpose of agency is to extend the personality of the principal through the facility of the agent. In agency by legal fiction, the actual or real absence of the principal is converted into his legal or juridical presence. Qui facit per alium facit per se. Illustrations: Joanne asked for her close friend Isa to buy some groceries for her in the supermarket. Was there a nominate contract entered into between Joanne and Isa? In the affirmative. What was it? Explain. 2003. Yes, there was a nominate contract of agency. Article 1868 of the New Civil Code provides that by the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another, with the consent or authority of the latter. In this case, Isa bound herself to render the service of buying groceries. A foreign manufacturer of computers and a Philippine distributor entered into a contract whereby the distributor agreed to order 1,000 units of the manufacturer's computers every month and to resell them in the Philippines at the manufacturer's suggested prices plus 10%. All unsold units at the end of the year shall be bought back by the manufacturer at the same price they were ordered. The manufacturer shall hold the distributor free and harmless from any claim for defects in the units. Is the agreement one for sale or agency? The contract involved is agency. The problem does not involve a contract of sale. There are circumstances that indicate the existence of an agency to sell, including the fact that the price is fixed by the manufacturer, with a 10% markup constituting the commission. The fact that the manufacturer reacquires the unsold units at exactly the same price and the fact that there is warranty for the units was borne by the manufacturer. Those facts indicate the intention not to transfer ownership to the distributor. Kinds of principal illustration. A is an agent of B. In transacting business for and on behalf of B, he issued his own personal checks in payment of B's obligation without disclosing his principal. Can he be held personally liable? Yes. A party who signs a bill of exchange as an agent but fails to disclose his principal becomes principally liable. PB Com versus Aduego, January 31st, 1981. Kinds of agent case illustration. A went for a car wash to BGH Petron gas station operated by B. However, while the car was being raised, the elevator shaft broke and the car slammed to the ground, causing damage valued at 100,000. Charter Ping An, the insurer of the car, paid A the damage, but in return, Charter Ping An sued Petron Philippines for the refund of the damages that it paid to A. Petron Philippines, however, moved for the dismissal of the complaint, alleging that BGH Petron gas station is an independent contractor, hence could not be held liable thereon. Is the contention of Petron Philippines tenable? No. The contract entered into between Petron Philippines and BGH Petron Gas Station is a contract of agency. The fact that BGH Petron Gas Station is an agent of Petron Philippines is clear from the fact that the equipment which the former uses in its service station belongs to Petron Philippines. More so, the oil, gasoline, and other product which is sold to the public are being sold by BGH Petron Gas Station on a commission basis only. Shell Company versus Fireman's Insurance Company, L 5169. Agency as to form, express versus implied. Express agency, it is expressly agreed upon by the parties and could either be in writing or oral. Implied agency. The agency is presumed from the acts of the principal, from his silence or lack of action, or his failure to repudiate the agency, knowing that another person is acting on his behalf without authority. What is the difference of verbal versus formal? Oral, no written proof of the agency, while under formal, the law requires a specific form. Examples: authority to sell a piece of land, of interest thereon. The SPA must be in writing, otherwise the sale is void. How about contractual versus legal? Contractual agency or agency by contract. The relationship between the principal and the agent is created through the agreement of the parties, while under legal or agency created by law, the relationship between the principal and the agent is created by law. In the cases where the law creates an agency, the parties did not agree, but the law recognizes the relationship between the agent and the principal. Illustration: X, signing as an agent, sold to Y a piece of land that belonged to his father. The fact, however, is that no power of attorney has been executed in his favor. When the father of X learned about this, he, the father, informed in the presence of witnesses that he would abide with the sale between X and Y. Can Y sue X for the enforcement of the sale? No. Article 1874 provides that in the sale of a piece of land or any interest therein to an agent, the authority of the agent must be in writing, otherwise the contract of sale is void. The ratification made by the father of X is of no moment, considering that the contract of sale being void, it cannot be validated. What is implied agency? Implied agency is implied from the agent's acts which carry out the agency, or from his silence or inaction according to the circumstances. What are the rules in case of implied agency between persons who are present, between persons who are absent? Exception: when the principal transmits his power of attorney to the agent who receives it without any objection. When the principal entrusts to him by the letter or telegram a power of attorney with respect to the business in which he is habitually engaged as an agent, and he did not reply to the letter or telegram. How about agency by estoppel? The principal, by his actions or representation, is barred from questioning the existence of agency. There is no true agency. Difference between agency by estoppel versus implied agency. Under implied agency, as between the principal and the agent is a true agent with the rights and duties of an agent. Agency by estoppel, as between the principal and agent, the agent is not a true agent, hence he has no rights as such. Implied agency as to third person. The principal is always liable. Agency by estoppel as to third persons. If the estoppel is caused by the principal, he is liable, but only if the third person acted on the misrepresentation. Under implied agency, the agent is never personally liable. Under agency by estoppel, if the estoppel is caused by the agent, it is only the agent who is liable, never the alleged principal. General agency and special agency. Difference. This refers to the scope of business covered by the agency. In general agency, the agency comprises all the business of the principal. In special agency, the agency is for one or more specific transactions. According to power or authority, the agency may be couched in general terms and in specific terms. Agency couched in general terms. An agency couched in general terms comprises only acts of administration, even if the principal should state that he withholds no power or that the agent may execute such acts as he may consider appropriate, or even though the agency should authorize a general and unlimited management, as in 1959 and 1992 bar. Persons dealing with an agent must ascertain not only the fact of agency but also the nature and extent of the agent's authority, especially if the act of the agent is unusual in nature. Agency couched in special terms. Specific powers are given to the agent under this type of agency. Example: a special power of attorney is an agency couched in special terms. Article 1878 provides that special terms are necessary for the following powers: to make such payments as are not usually considered as acts of administration. 2. To effect novations which put an end to obligations already in existence at the time the agency was constituted. 3. To compromise, to submit questions to arbitration, to renounce the right to appeal from a judgment, to waive objections to the venue of an action or to abandon a prescription already acquired, to waive any obligation gratuitously. 5. To enter into any contract by which the ownership of an immovable is transmitted or acquired either gratuitously or for a valuable consideration. 6. To make gifts, except customary ones for charity or those made to employees in the business managed by the agent. 7. To loan or borrow money, unless the latter act be urgent and indispensable for the preservation of the things which are under administration. 8. To lease any real property to another person for more than 1 year. 9. To bind the principal to render some service without compensation. 10. To bind the principal in a contract of partnership. 11. To obligate the principal as the guarantor or surety. 12. To create or convey real rights over immovable property. 13. To accept or repudiate an inheritance. 14. To ratify or recognize obligations contracted before the agency, and 15. Any other act or strict dominion. So even if the document is entitled General Power of Attorney, and even if general powers of administration are also conferred, the requirement for a special power of attorney is complied with if the general power of attorney includes specific powers. Thus, a document may be a general power of attorney, but it may contain a specific power to sell or mortgage a specific parcel of land. Agency to lease a parcel of land for more than 1 year requires a special power of attorney. Power to sell. A special power to sell excludes the power to mortgage, and a special power to mortgage does not include the power to sell. A special power to compromise does not authorize submission to arbitration. What is the effect of absence of specific authority? If specific authority is required under Article 1878 and no such authority was given, the transaction of the agent with the third person is unenforceable. The transaction cannot be enforced, but it may be ratified by the principal. Exception when void. Sale of land is void if there is no written authority given to the agent. Illustrations. A, as agent of B, is in possession of general powers of administration. Pursuant thereto, he executed in favor of X a contract of lease for a period of 10 years for a consideration of 10 million. More so, he likewise executed another contract of lease in favor of Y for a consideration of 10,000 per month for a period of 10 months. What is the status of these contracts? And so far as the contract of lease for 10 years, it is void because it is considered as an act of ownership. Thus, his general power of attorney is not sufficient. And so far as the contract of lease for 10 months, it is valid since contract of lease for a period of at least 1 year is considered as an act of administration. Thus, his general power of attorney would be sufficient. Illustration number 2. X executed a special power of attorney authorizing Y to mortgage his land. However, instead of mortgaging the property, he instead sold the same. Is the sale valid? No, because the special power of attorney to sell excludes the power to mortgage, and the power to mortgage does not include the power to sell. Article 1879. What are the fundamental principles of agency? There are two very important principles of a true agency. The agent must act within the scope of his authority, and B, the agent must act in behalf of his principal. Illustration. A constituted B as agent to sell his house and lot for 10 million cash. B, however, was able to sell it for 11 million, where 10 million in cash and 1 million by installments. Was there violation of his authority? None. The limits of the agent's authority shall not be considered exceeded if it was performed in a manner more advantageous on the part of his principal. Question 2. How about if B was able to sell it for 11 million by installment? Was there violation of his authority? Yes, because his authority is to sell it for cash and not by installments. The rule which provides that the limits of the agent's authority shall not be considered exceeded if it was performed in a manner more advantageous on the part of his principal, shall be understood in a way that the very nature of such authority should not have been violated. Requisites of agency. The Supreme Court has enumerated the following essential elements. 1. Consent, express or implied, of the parties to establish the relationship. 2. The object is the execution of a juridical act in relation to a third person. And 3. The agent acts as a representative and not for himself. 4th, the agent acts within the scope of his authority. Consent. The contract of agency is generally consensual. Hence, it can be perfected by mere consent. Exceptions are formal agencies where the law requires certain formalities, like an agency to sell land, which the law requires to be in writing. Intention of the parties is also indispensable. The intention by the principal to appoint the agent and the intention of the agent to accept must be present. However, both intentions may be expressly given or may be implied from the actions of the parties. The principal need not personally know or meet the third person with whom her agent transacts. What is acceptance by an agent? Acceptance may be A, expressed, or B, implied from the agent's acts which carry out the agency, or from his silence or inaction according to the circumstances. Between persons who are present, the acceptance of the agency may also be implied if the principal delivers his power of attorney to the agent and the latter receives it without any objection. Between persons who are absent, the acceptance of the agency cannot be implied from the silence of the agent. Exceptions: between persons who are absent, agency may be implied from the silence of the agent in the following cases: when the principal transmits his power of attorney to the agent who receives it without any objection, and 2, when the principal entrusts to him by letter or telegram a power of attorney with respect to the business in which he is habitually engaged in as an agent and he did not reply to the letter or telegram. Effect of notice of appointment to agent. Special notice. If a person specially informs another that he has given a power of attorney to a third person, the latter thereby becomes a duly authorized agent with respect to the person who received the special information. Through advertisement. If a person states by public advertisements that he has given a power of attorney to a third person, the latter thereby becomes a duly authorized agent with regard to any person. How to rescind. The notice of rescission should be in the same manner in which the agency was given. Example: if the agency was given in a public instrument, then the notice of rescission should also be in a public instrument. Agency may be onerous or gratuitous. Agency is presumed to be for compensation unless there is a proof to the contrary. Procuring cost rule. The agent is entitled to the stipulated compensation in the execution of the powers granted to him, if the act of the agent is the procuring cost of the transaction. Thus, in an agency to sell, the agent is entitled to a commission if he is the procuring cost of the sale. This means that the sale must be concluded to the measures that the agent employed and the efforts that he exerted. Distinguish it from brokers. Unlike agents, brokers do not represent a principal. A broker is one whose occupation is to bring the parties together in matters of trade, commerce, or navigation. With respect to compensation of brokers, the action of the agent must also be in the procuring cost, which is the cost originating a series of events which, without break in their continuity, result in the accomplishment of the prime object of the employment of the broker. The broker's efforts must have been the foundation on which the negotiations resulting in a sale began. How about the subject matter? The object of the contract of agency is the prestation and power to represent the principal. The agent must perform the general or specific powers and functions conferred, expressly or impliedly, by the principal. Duties of an agent. An agent is a fiduciary. In the performance of such function, the agent must faithfully and diligently exercise his authority and must not commit acts or disloyalty against the principal. Hence, just like other persons that perform fiduciary duties, the general duties of an agent are duty of obedience, duty of diligence, and duty of loyalty. It's broken down as obligations of the agent. 1. To carry out the agency and be liable for damages in case of non-performance. 2. To finish the business already begun on the death of the principal, should delay entail any danger. 3. To act within the scope of his authority. What happens if the authority exceeded? The following are the rules if the agent contracts in the name of the principal, exceeding the scope of his authority, and the principal does not ratify the contract. The contract entered into if the agent exceeded his authority is unenforceable as far as the principal is concerned. Exception: if the principal ratified. When is the contract void as to the agent? The contract is void if these concur. 1. The contract was entered into by the agent who exceeded his authority, and 2. The party with whom the agent contracted is aware of the limits of the powers granted by the principal. In this case, however, the agent is liable if he undertook to secure the principal's ratification. What is apparent authority? The principal may be bound by an apparent authority given by the agent. The principal is liable if he clothes his agent with authority in the eyes of third persons. Example: So far as third persons are concerned, an act is deemed to have been performed within the scope of the agent's authority if such act is within the terms of the power of attorney, as written, even if the agent has in fact exceeded the limits of his authority according to an understanding between the principal and the agent. The doctrine of apparent authority is also known as the holding out theory or doctrine of ostensible agency. Anybody who makes it appear that the agent is authorized is bound by the acts of the agent. However, apparent authority is determined only by the acts of the principal and not by the acts of the agent. Fourth, to advance the necessary funds, should there be a stipulation to that effect, except if the principal is insolvent. 5. To act in accordance with the instructions of the principal, in default thereof, he shall do all that a good father of a family would do. 6. Not to carry out the agency if its execution would manifestly result in loss or damage to the principal. 7. To be liable for damages if there being a conflict between his interests and those of his principal, he should prefer his own. 8. To render an account of his transactions and to deliver to the principal whatever he may have received by virtue of the agency, even though it may be not owing to the principal. This duty includes 1. The duty to disclose all the agent's transactions and material facts in connection with the agency, and 2. To deliver to the principal whatever he may have received by virtue of the agency, even though it may not be owing to the principal. This includes profits, bonus, gratuity, or any personal benefits or advantage. Every stipulation exempting the agent from the obligation to render an account shall be void. This is meant to stress the highest degree of loyalty that is required of agents. Liability for appropriating the principal's property. If the agent does not turn over what he received in behalf of the principal, he may be held liable for estoppel under Article 315, Number 1, letter B of the Revised Penal Code. In addition, the agent owes interest on the sums he has applied to his own use from the day on which he did so, and on those he still owes after the extinguishment of the agency. Illustration: X authorized Y to sell his house and lot for 10 million cash with a 5% commission. Y was able to sell the same for 12 million cash. For what amount is Y accountable to X? He is accountable for 12 million. Article 1891 provides that the agent is bound to render an accounting of his transaction to his principal, even if such amount is not owing to his principal. And 9. To act by himself or to a substitute. Sub-agent or substitute. The agent may appoint a substitute if the principal has not prohibited him from doing so. The principal is then bound by the acts of the substitute. The agent and the substitute shall be responsible for the acts of the substitute when the agent was not given the power to appoint one, and 2, when the agent was given such power but without designating the person, and the person appointed was notoriously incompetent or insolvent. What are the void acts of subagent? If the agent is prohibited to appoint a substitute, all acts of the substitute appointed against the prohibition of the principal shall be void. What is the doctrine of representation? Notice to an agent is notice to the principal. However, the agent may be sued or be sued solely in his own name and without joining the principal when the following elements concur. 1. The agent acted in his own name during the transaction. 2. The agent acted for the benefit of an undisclosed principal. And 3. The transaction did not involve the property of the principal. What is a commission agent? Commission agent is one who is engaged in the business of receiving, handling, and selling of goods for commission, whether in his own name or in that of another. He is also known as a factor. What is sale on credit? The commission agent cannot sell on credit without the consent of the principal, express or implied. If he was authorized to sell on credit, he should inform the principal of such sale on credit, otherwise the principal can deem it as cash sale. What is a guarantee commission? This is a commission that is given in addition to the ordinary commission. The guarantee commission is given so that he can bear the risk of collection and pay the principal the proceeds of the sale on the same terms agreed upon with the purchaser. To differentiate, ordinary commission is a fee for compensation for the sale of the goods, which are placed in his possession and at his disposal, while guarantee commission is also known as del credere commission, which is merely an additional compensation for the risk of collection. Example, as an agent, Al was given a guarantee commission in addition to his regular commission after he sold 20 units of refrigerators to a customer, HT Hotel. The customer, however, failed to pay for the units sold. Al's principal, DRBI, demanded from Al payment for the customer's accountability. Al objected on the ground that his job was only to sell and not to collect payment for units bought by the customer. Is Al's objection valid? Can DRBI collect from him or not? Reason: no, Al's objection is not valid. Al is liable to DRBI. Article 1907 of the New Civil Code provides that should the commission agent receive on a sale, in addition to the ordinary commission, another called a guarantee commission, he shall bear the risk of collection and shall pay the principal the proceeds of the sale on the same terms agreed upon with the purchaser. Article 1907 applies because Al, as an agent, received not only a regular commission, but also a guarantee commission. Obligations of the principal. The principal has the obligation to 1. Comply with all the obligations which the agent may have contracted within the scope of his authority. 2. Comply with all the obligations which the agent may have contracted not within the scope of his authority, but has ratified expressly or tacitly. 3. Comply with all obligations solidarily with the agent which the agent may have contracted not within the scope of his express authority, but the principal allow the agent to act as though he had full powers. 4. Pay or reimburse the advances of the agent necessary for the execution of the agency without the fault of the agent. 5. Indemnify the agent for all the damages which the execution of the agency may have caused the latter, without fault or negligence on his part. When is the principal not liable for expenses? The principal is not liable for the expenses incurred by the agent in the following cases. 1. If the agent acted in contravention of the principal's instructions, unless the latter should wish to avail himself of the benefits derived from the contract. 2. When the expenses were due to the fault of the agent. 3. When the agent incurred them with the knowledge that an unfavorable result would ensue if the principal was not aware thereof. 4. When it was stipulated that expenses would be borne by the agent, or that the latter would be allowed only a certain sum. What happens if there are two principals solidarily liable? If 2 or more persons have appointed an agent for a common transaction or undertaking, they shall be solidarily liable to the agent for all the consequences of the agency. What happens if both agent and principal transacted? When 2 persons contract with regard to the same thing, one of them with the agent and the other with the principal, and the 2 contracts are incompatible with each other, that of prior date shall be preferred without prejudice to the provisions of Article 1544. If the agent has acted in good faith, the principal shall be liable for damages to the third person, whose contract must be rejected. If the agent acted in bad faith, he alone shall be responsible. Illustrations. On March 1, 2020, A appointed B to be his agent for the sale of his house and lot located in Baguio City. Notwithstanding the appointment of B as agent, A, the principal, on March 20, 2020, was able to sell the land to C. However, the said sale was not registered with the Registry of Deeds. On the other hand, pursuant to his authority, on April 1, 2020, B, agent, sold the same parcel of land to D, who in turn immediately registered the sale. When C discovered the sale and transfer, he went to court and asked for a reconveyance. Will the action prosper? No. When two persons contract with regard to the same thing, one of them with the agent and the other with the principal, and the two contracts are incompatible with each other, that of prior date shall be preferred, without prejudice to the provisions on double sale under Article 1544. Article 1916. In this case, B can be presumed to be a buyer in good faith and for value. Hence, the action for reconveyance will not prosper. What are the modes of extinguishment of agency? Agency is extinguished by its revocation, express or implied, and may be done at will or at any time by the principal. 2. By the withdrawal of the agent by giving due notice to the principal. 3. By the death, civil interdiction, insanity, or insolvency of the principal or the agent. 4. By the dissolution of the firm or corporation which entrusted or accepted the agency. 5. By the accomplishment of the object or purpose of the agency. 6. By the expiration of the period for which the agency was constituted. Examples of implied revocation. The agency is revoked if the principal directly, with intent to revoke, manages the business entrusted to the agent, dealing directly with third persons. 2. A general power of attorney is revoked by a special one granted to another agent, as regards to the special matter involved in the latter. Withdrawal of agent. The agent may withdraw from the agency by giving due notice to the principal. If the latter should suffer any damage by reason of the withdrawal, the agent must indemnify him therefor, unless the agent should base his withdrawal upon the impossibility of continuing the performance of the agency without grave detriment to himself. Tort liability. The principal may be held liable for tort under Article 2180 for the acts of the agent. The liability may be vicarious in nature. When is it irrevocable? An agency cannot be revoked if a bilateral contract depends upon it, or if it is the means of fulfilling an obligation already contracted, or 3. If a partner is appointed manager of a partnership in the contract of partnership and his removal from the management is unjustifiable. 4. Agency coupled with interest. What is agency coupled with interest? If it has been constituted 1. In the common interest of the principal and of the agent has interest distinct from the principal, or in the interest of a third person who has accepted the stipulation in his favor. This type of agency shall remain in full force and effect even after the death of the principal. It cannot be revoked except for cause. It is necessary that the interest is specified in the power of attorney, and it must be an interest in the subject matter of the power conferred and not merely an interest by reason of the compensation to be given to the agent. Thus, the mere fact that the agent is for compensation does not mean that the agency is coupled with interest. Example, a developer introduced improvements on the subdivided property belonging to another at the developer's expense, with the agreement that the developers are constituted as an agent with the special power to sell the lots included in the project. Other grounds would be termination by mutual consent, loss of the subject matter of the agency, change of law, outbreak of war, if inconsistent with agency. Illustrations. A and B both appointed C to be their agent to sell their registered property. Can A alone revoke the special power of attorney? Yes, because when two or more principals have granted a power of attorney for a common transaction, any one of them may revoke the same without the consent of the other. This is a consequence of the solidarity liability of two or more principal. Case number 2. Anton is indebted to Bart in the amount of 100,000. Anton, however, failed to pay the same, so that Anton will be able to pay his obligation. Bart appointed him as his collection agent to collect the loan obligation of Charlie in the amount of 1 million, with the condition that if Anton would be successful in collecting said amount, his obligation to Bart is deemed fully satisfied. A week after such appointment was made, Bart wrote Anton revoking the agency. Is the act of Bart proper? No, because this is an agency coupled with interest, or it is the means of fulfilling an obligation already contracted. In view thereof, the agency cannot be revoked at will by the principal, as in by way of an exception to the rule that agency is generally revocable. Case number 3. Anton was expressly authorized in writing to sell the house and lot of Bart. On April 1, 2020, Anton, without being aware of the death of Bart due to COVID-19 on March 1, 2020, sold the property to Charlie, who is fully aware of Bart's death. What is the status of such contract of sale? The contract is not valid. This is because Charlie acted in bad faith, he being aware of Bart's death. Under Article 1931, it provides that anything done by the agent without the knowledge of the death of the principal or of any other cause which extinguishes the agency is valid and shall be fully effective, with respect to the third person who may have contracted with him in good faith. In this case, Charlie is in bad faith, thus the contract is not valid. Question number 2. What is the duty of Charlie, if any, in this case? A person dealing with an agent must investigate, otherwise he acts at his own peril. Manila Memorial Park Cemetery versus Linsangan, GR 151391, November 22, 2005. But if the third party is in good faith, anything done by the agent without knowledge of the death of the principal or any other cause which extinguishes the agency is valid and shall be fully effective with respect to third persons who may have contracted with him in good faith. Example, the sale is valid if the agent executed the deed of absolute sale on behalf of his principal 2 days after the principal died, an event that neither the agent nor the buyer knew at the time of the sale. 2011 bar. Other examples from the book of Aquino. 1. Richard sold a large parcel of land in Cebu to Leo for 100 million, payable in annual installments over a period of 10 years. But title will remain with Richard until the purchase price is fully paid. To enable Leo to pay the price, Richard gave him a power of attorney authorizing him to subdivide the land, sell the individual lots, and deliver the proceeds to Richard, to be applied to the purchase price. 5 years later, Richard revoked the power of attorney and took over the sale of the subdivision lots himself. Is the revocation valid or not? 2001 bar. The revocation is not valid. Generally, an agency can be revoked at will by the principal. However, under Article 1927 of the New Civil Code, an agency cannot be revoked if a bilateral contract depends on it, or if it is the means of fulfilling an obligation already contracted. In the present case, the agency is the means of fulfilling the obligation to pay the price of the lot to Richard. The fulfillment of the bilateral contract of sale is also dependent on the agency. Hence, Richard cannot revoke agency. Number 2. FB is the owner of a parcel of land. FB executed the special power of attorney in favor of AC, authoring AC to borrow money and use his parcel of land as a collateral for the loan. AC agreed to defray the costs and expenses in processing the loan based on the promise of FB that AC will have an equal share in the proceeds of the loan or the subject property. AC advanced the amount of 500,000. Can the SPA be revoked at will by FB? No. The special power of attorney cannot be revoked at will by FB. What FB executed is an agency coupled with interest. The bilateral contract between FB and AC depends upon the agency. Ching versus Bentolo et al., TR number 177086, December 5, 2012. And that concludes the subject on agency. If you're not yet subscribed to our channel, go ahead and hit that subscribe button. It's free. It helps me feel good. You spread the love too, and go ahead and share.